Good afternoon, everyone, and welcome to another question and answer session live. My name is Samara Belitzky, and I'm an employment lawyer at Samfiru, Tumarkin. I work out of our Ottawa office, but I serve clients from all over Ontario as well as BC. And I'm here, as I am on many Fridays throughout the year, to give you all of the answers to the questions that you have, whether it's related to issues you're having in the workplace, health and safety issues, maybe it's changes to your terms and conditions of your work, or terminations, questions about severance and termination entitlements, whatever the question might be, if it's related to employment law, workplace issues, whatever the case, I'm here for the next half hour or so to answer your questions. So please send your questions in. Happy to answer any questions you might have. While we're waiting for some of the questions to come in, as usual, I have my list of topics that I wanted to talk about. I don't often get to my list, or sometimes I only get through one or two things, depending on how many questions we get, because of course we're here to answer your questions. So I'd much rather answer your questions than talk about my list that I have prepared here. But I'll get to this list and start talking about some of the topics I had top of mind for today while we wait for the questions to come in. So everyone, please send in your questions, here to answer them. Happy to help you however I can. So the first thing that I wanted to talk about is something that I've been getting a lot of questions about, I'd say over the last few months. So even since July, we've been getting a lot of questions, but for some reason, I've been getting more and more questions about it this past week. And that's with respect to layoffs that happened during the pandemic. So I've been getting questions from lots of people who have been laid off. Maybe it was in 2020, 2021, even earlier this year, because of COVID, or allegedly because of COVID. They've been laid off and they haven't been called back to work yet. So if you're in that situation, you should absolutely contact us right away, because there was a law in place that some of the employers were trying to rely on to try and get out of having to pay severance to people that they unlawfully put on layoffs, meaning they put on a layoff without the employer having the right to do it, which means it's a termination and that employee is owed their severance. So there was a law that was put in place by the Ontario government, and it was called Infectious Disease Emergency Leave. And even though it didn't necessarily assist the employers in getting out of their obligations to pay severance, a lot of employers were kind of using that law as an excuse, kind of hiding behind that not to pay out what they should. Now that law has gone away as of the end of July of this year. So if you're on a layoff and you are not called back by the end of July of 2022 of this year, then you can pursue it as a termination like you could before. The only difference is that now there's nothing that the employers can try to use to get out of trying to provide what they have to. And so moving forward, it's really important to act quickly. If you're one of those people who haven't been called back to work at the end of July, get in touch with us right away so that we can assist you in going after what you're owed. We've been doing this for many people since, many people during the pandemic. For the last few years, we've been doing it. But for people who haven't been called back and were waiting to be called back before doing anything, they were hoping to go back to work maybe, and now it's clear to you that, it's been over 2.5 years or 2 years, you're not being called back. Get in touch with us because we can assist you in pursuing this like we've been doing for many other people in the exact same situation. Go after and get you your severance that you're owed. It's important, if you're in this situation, to get in touch with us right away. Don't wait any longer because time is of the essence with these kinds of claims. So you want to be putting forward your claim sooner rather than later. So you'll need to get in touch with us so that we can put forward your claim for you and go after what you're owed. You can always contact me directly. You can also email the firm directly at help@employmentlawyer.ca. You can call us, you can email us at the email address I just described. Our phone number is on the screen right now. And then if you do want to contact me directly, you can always go to our website, employmentlawyer.ca, and you can contact me that way. All of my contact information is on our website, okay? So that's something that I wanted to address because we seem to have had a bit of a resurgence of these issues coming up. There still are lots of people out there who were put on a layoff during the pandemic and still have not been called back to work. If you're one of those people, or you know someone in that situation, tell them to get in touch with us, or you yourself get in touch with us, because you want to make sure that you're going to receive what's legally owed to you. So that is an issue that I wanted to address. We have some questions coming in here, so I'll get to the questions that are coming in. I have a question from Trevor on Facebook, who asks, what are your options if your contract mentions you can be put on a layoff? Okay, so kind of piggybacking off of this issue that I was mentioning, great question. So what's important to know is, I'll take a step back for a moment just to explain how it works when it comes to layoffs. And when I say layoffs, I mean temporary layoffs, because oftentimes when we're talking about terminations, outright terminations of employment, people use those terms interchangeably in conversation. You know, I've been laid off from my job, I've been let go, I've been terminated, I've been fired. But when we're talking about a layoff, the actual legal definition is a temporary layoff. Now, normally when employers are implementing temporary layoffs, it's because of a slowdown in business. That's most of the time when we're seeing that. And where we often see that is in industries that are seasonal. Oftentimes in the construction industry, we'll see a slowdown in the winter. If you work for a snow removal company, you may have layoffs in the summer. So seasonal work definitely does tend to have layoffs. Now, where we see layoffs occur, excuse me, it doesn't necessarily mean that they're lawful. And so when we're talking about layoffs are only lawful when they're either mentioned in an employment contract or some other document that the employee has signed, and it says specifically that you agree as an employee that the employer is allowed to put you on a temporary layoff in accordance with the Employment Standards Act, and it won't be a termination of your employment. So that's one way where it can be lawful. The other way that it can be lawful is if the employer implements a temporary layoff, you accept the layoff. In other words, you go on your layoff and you get called back to work, you go back to work, business as usual. Once there's a layoff in place that occurs in that manner, you've accepted that a temporary layoff will become part of the terms and conditions of your employment as an employee. That means the employer has a precedent they can rely on. They can now lay you off again in the future. That's why it's so important that if, let's say, you don't have a contract, you don't have anything as an employee that you've signed, if an employer is implementing a temporary layoff for the first time, you need to act on it right away. If you do nothing and you go on your layoff and then you go back to work, you're giving them the right to do it again and again and again. Now, in terms of it being in a contract, if the contract mentions it, there's a few ways that we've seen this come about. Some employers, very, very few of them, already had this in their employment contracts before the pandemic. Employers that have gone to see an employment lawyer to make sure that their contracts comply with the law and make sure that everything is in place to limit liability, those employers may have already had temporary layoffs in their contracts. Most of them didn't. Most of them had to learn the hard way during the pandemic that layoffs are not legally implemented or cannot be implemented legally unless it's in the contract or you've laid off before. If neither of those things have existed before, no contract, nothing in writing, no precedent, no previous layoff, then the employee can treat that layoff like a termination of their employment and go after their severance. So this is something that has been quite prominent during the pandemic because lots of people were laid off for the first time without the employer having the right to do it. So if you're in that situation, you need to contact an employment lawyer right away, like many people did during the pandemic, to assist you in your situation. Sometimes it's you want to get back to work, we can assist you in getting called back to work. Otherwise, severance is what you would be pursuing. And we've assisted lots of people with that, especially during the pandemic. Now, in terms of the contracts, as I was saying before, we didn't see them in a lot of contracts before the pandemic. Now we see it a lot more. A lot of employers have updated their contracts because of the pandemic, because they've learned about layoffs and how they work. And so if your employer is presenting you with a new contract, the odds are that that new contract is going to have an updated termination clause where they try to limit your severance rights. and a temporary layoff clause. So those are the two main things that you'll likely see. If you're presented with a new contract, you should be getting it reviewed by an employment lawyer no matter what. Even if you look through and you think, okay, there's no temporary layoff clause, or the termination clause looks okay to me, it's still important to get it reviewed by a lawyer because there may be things in there that you're not aware of that can have a huge impact on your rights as an employee moving forward, namely your severance rights, but other rights as well. And when it comes to those contracts, you don't have to sign them. So if you are presented with a contract with a temporary layoff clause in there, you don't have to agree to that. You don't have to sign the contract. You have a choice. The employer might pressure you. They might tell you you have to sign it, but you don't. You do have a choice. Now, in terms of what could happen if you don't sign, it is possible that an employer lets you go because you don't sign a contract. Most of the time, they won't do that. But in the odd occasion where they will let someone go if they don't sign the new contract, well, at least you've maintained your right to full severance. So if you don't sign the contract and they let you go, you're not limited in your severance to whatever that contract might say. You're still owed your full severance and we can help you go after that. So at least there's not a trade-off on your severance. So if they're presenting you a contract like that, you don't have to sign. If you're at the beginning of employment, you've been offered a new job and you see in the contract that there's a temporary layoff clause, again, you don't have to sign, you don't have to start the job there, but the odds are you probably do want to take that job. You can try to negotiate. Again, always see an employment lawyer, always get your contract reviewed by an employment lawyer first. I often assist people in trying to negotiate different parts of their contracts in getting the employer to either adjust certain things, revise certain things, or remove them altogether. So there are different things that can be done. And I give people advice on this all of the time, but you do have to go to an employment lawyer first to make sure that we can see what's what and see how we can help you. If you agree to a temporary layoff clause in a contract, if you sign the contract, whether it's a new contract where you're starting a new job or you're continuing your employment, but your employer wants you to sign a new contract, regardless of the situation, if you do sign a contract where there is a temporary layoff clause, you will be stuck with it. And that means that the employer can lay you off on a temporary basis in accordance with the Employment Standards Act. Now, just to give you an example, in Ontario, if you agree to a temporary layoff under the Employment Standards Act, if that's in your contract, that means that the employer has the right to put you on a temporary layoff for up to 13 weeks if they don't continue your health benefits, or if you simply don't have health benefits, up to 13 weeks. And if you do have health benefits and they continue your health benefits, then you can be laid off for up to 35 weeks. And then if they don't call you back before the 13-week or the 35-week deadline, it becomes a termination and you're owed your severance. So that's the usual rule when it comes to temporary layoffs that are allowed. Now, a lot of employers think that that applies regardless of having a contract. So if you have no contract that has a temporary layoff clause, you've never been laid off before, a lot of employers think that because it's outlined in the Employment Standards Act, that they have the right to do it right off the bat. And they don't. It still has to be in a contract or there needs to be a precedent. And if that's the case, then it is a lawful layoff, which rarely does happen, but it does happen. Then it's that 13 or 35-week deadline. Now, the reason why it's become so important during the pandemic when we're talking about layoffs is because during the pandemic, the Ontario government, and again, I'm just talking about Ontario right now, it did work differently in other provinces where the extension was not quite the same, but Ontario had the longest, one of, if not the longest extensions. And again, they turned it into infectious disease emergency leave under the Employment Standards Act. So it was extended for over 2 years. So that's something that could really complicate matters if you're somebody who has agreed to a layoff or you have it in your contract. Now, that doesn't mean there isn't a way to get around it sometimes. Sometimes you've been offered a new contract, you're already an employee, you've been offered a new contract and you sign it. But there are things in the contract or there are ways in which the contract was implemented that make it null and void and unenforceable. So if there's any way around it, we'll find it for you. But just, from a starting off point, if you can avoid having that be a term of your employment, you absolutely should, because it is not in your favor as an employee. As an employer, it's completely in the employer's favor to have that in place. If your contract does mention it and you're worried about it, if you're put on a layoff and you do see there is something in your contract about it, get in touch with us to get it reviewed, because you might not be stuck with it. It's possible that you are, which is why you always want to get your contracts reviewed before you sign them. But there are circumstances where there are ways around it. So always get in touch with us to make sure that you know exactly what the law says about your situation and see what can be done about it, if anything. So I'm just getting to a few more questions here. I have a question from Ryan on YouTube, who says, I have read about managers excluded from protection. I have been working for a company for nearly 5 years, with the last 8 months as an assistant manager. It's looking like I'm being demoted. What are my rights? Okay, so in terms of reading about managers excluded from protection, I'm not sure what protection specifically you're referring to here, Ryan, but there are different rules for people who are in managerial positions, for example, when it comes to overtime. So managers are not entitled to receive overtime pay. There are a lot of conditions that apply to that and circumstances that surround it, but generally speaking, managers are excluded from that, whereas regular employees who are not managers would be entitled to overtime pay under employment standards legislation. So that's something I can think of where it kind of aligns with what you're talking about. But if there's something more specific that you mean, please feel free to send in a follow-up question here. In terms of your situation of being demoted, you're not allowed to be demoted, whether you're a manager, not a manager, wherever you lie in the hierarchy of your company. Employers cannot just demote you unilaterally. So they can't just decide one day out of the blue that you might be a manager, you're not going to be a manager anymore. They're not allowed to do that without your consent. So in that situation, you have a choice. You can either consent to the change that they're trying to impose on you and force on you, or you can refuse it. And if you refuse it and the employer continues to force it on you anyway, then you can treat that like a constructive dismissal, like a termination of your employment, and go after your severance. So employers do not have the right to make unilateral changes without your consent. They have to also, in order to meet that threshold, in order to be considered a constructive dismissal, a termination of your employment, they have to meet a certain threshold. The changes have to be significant. So the employer is allowed to make certain changes that are not significant to the conditions of your employment. They're not allowed to make permanent and significant changes to the main terms of your employment without your agreement. A demotion would fall under that category. So they're not allowed to demote you without your agreement. So in this situation, Ryan, you can refuse it. Make sure you refuse it in writing. If you're in a situation where your employer is trying to force changes on you that you're refusing, it's great to say it verbally. It's great to express that you refuse it verbally, but that is not where the refusal stops. You have to do it in writing, whether it's by email, by text message. Email is preferred, but I had actually a client the other day who did it by email, by text message. That's fine. It's in writing. There's a record of it. That's what's important. You need to have a record of it that you can fall back on to show that you've refused the changes. So you need to send an email, whether it's to your boss, whether it's to HR, whoever you're dealing with, and tell them that the changes are too significant for you to agree to, and you've refused them. From there, you would be in a situation where it depends on how they respond. And that's why it's so important to speak to a lawyer. That's kind of the first step in terms of making sure you refuse the changes. But you do have to get legal advice for your exact situation, because every single situation is different. I often have people that come to see me. I have consultations with them. Changes are being made to their jobs, to their duties, to their hours, and we have a discussion about everything. And I give them advice, behind the scenes. How do you deal with your employer? What should you say? Make sure it's in writing. And I help behind the scenes unless and until it's time to get involved. like I said before, if your employer is going to keep forcing these changes on you, even after you refuse them, then you will be able to treat that like a constructive dismissal and go after your severance. But you have to do it with an employment lawyer. You cannot do that on your own because it's too risky. You might do something that could potentially have a negative impact on your case. You want to make sure you stay in the strongest legal position possible, and we can absolutely help you do that. So Ryan, you said it looks like you're being demoted. If that actually does come to fruition, get in touch with me. I'm more than happy to help you, kind of help you navigate through this situation. If it turns out that you actually are being demoted, that it's being forced on you, then I would be able to assist you in pursuing a constructive dismissal claim. So you certainly have a legal leg to stand on here. They're not allowed to do that. Okay. I have a question from Vincent on Facebook who says, my daughter and her fiance both work at the same store. Her fiance is about to be promoted and now she's facing some bullying and snide comments from coworkers. There's rumors she'll be forced to move to a new location. What can she do? The first thing she should be doing is filing a complaint. It sounds like if they work at a store, I don't know how big the company is. Maybe it's a small boutique, maybe it's a chain store, a big box store, but she should be filing a complaint in writing about the harassment and the bullying that she's experiencing. That's step one. If it's a big organization, there will be an HR department that she should do that with. Otherwise, a manager, but there is someone that she should be filing this with, bringing it up. It's not enough to just raise it verbally. It has to be done in writing, okay? So that's number one. Once that's done and the employer is made aware of what's going on in writing, the employer then has an obligation to investigate. And once they investigate, they have an obligation to maintain health and safety in the workplace. So that means if they see that these issues are happening, they have to discipline the coworkers that are engaging in the bullying. And when I say discipline, that could mean up to and including firing them, letting them go, depends on how severe it is, and making sure that this stops. That's the employer's job. But they can't do anything about it unless you file that complaint first. So that is the first step. If, let's say, the employer refuses to investigate, or they do investigate, but nothing really comes from it, and this keeps happening, then you'll want to get a lawyer involved at that point. So tell your daughter that she can absolutely get in touch with me or our firm in general for assistance with this, but those would be the first steps in terms of addressing this issue. We have a question with respect to about the kind of on topic of new contracts that I was talking about before. The question is, does my employer have to give me a bonus or anything when I'm asked to sign a new contract? So as I kind of alluded to before, there are rules with respect to the enforceability of new contracts. So if you work for a company for, let's say, 10 years, and all of a sudden they want you to sign a new contract, when you sign that new contract, they have to give you something in exchange for agreeing to those new terms and conditions of employment. The legal term for that is called consideration. Okay, so they need to give you something in exchange. Most of the time, it's a salary increase or a raise. It doesn't have to be significant. If you're making, $30 an hour, they can move you to $31 an hour. If you're on a fixed salary, they can increase your salary by $1,000 a year. The other way they can do it is by giving you a signing bonus. By giving you a bonus, and again, the bonus doesn't have to be significant. It could be a few $100s. As long as something is given, if you sign that contract and you do receive something in exchange for it that you wouldn't normally have received, but for signing that contract, then the contract will be enforceable. It will be valid and you're stuck with it. On the flip side, if the employer doesn't give you anything for signing it, no wage increase, no raise, no extra, I've seen, extra weeks of vacation, whatever the item might be, it has to be something extra that you didn't have before. If they don't give you anything, no signing bonus, nothing, then the contract itself would not be valid, would not be enforceable, and it can't be used against you to either implement a temporary layoff, if there happens to be a temporary layoff clause in there, or limit your severance, if there's a clause in there that limits your severance. whatever the case may be, the contract would not be enforceable. So that's something to keep in mind moving forward. But again, these are the things that as employment lawyers, this is what we're trained to look at. We review. We are experts in looking at this and interpreting contracts. So if you have a question about that, you're not sure if you did receive what's called consideration, something for signing that new contract, get in touch with us. We can review it for you and let you know where you stand. I have a question from Chloe B on YouTube who says, I was just terminated. Sorry to hear that, Chloe. I've been with the company just shy of 5 years and I'm in middle management. They've offered 4 months severance. I'm in my late 40s. And then a follow-up question, how difficult is it to negotiate a severance package? Are employers reluctant to negotiate? Okay, so once again, Chloe, sorry to hear about that. But this is what we do. This is what I do all day, every day. I negotiate severance packages for people who've been let go and haven't been offered enough. In the vast majority of cases, people are not offered enough. In your case, in your late 40s, 5 years of service in middle management, I would say, 4 months is not enough. I'd have to see the offer to see exactly what they're offering you and how they're offering it to you. Because sometimes they'll offer it to you as a lump sum payment. Sometimes they'll offer it to you as salary continuation, where they continue it until you find a new job and then they stop the payment. So depending on the different factors that are surrounding the offer, my advice may vary. Chloe, I would recommend you get in touch with me right away. As I said before, my contact information is on our website. Go to employmentlawyer.ca and go to my profile and please email me. I'm happy to discuss this with you, review the offer for you, see where you stand. It sounds like what they've offered you does fall a little bit short of what you should be getting. So happy to assist you in pursuing that. And to answer your follow-up question, it's not usually very difficult for us to negotiate severance packages. Like I said, this is what we do. We are experts in this, and we are very successful in getting the packages that people deserve. So that's exactly what I would want to do for you. Just get in touch with me and we can go from there. So I have a few more questions. I don't think I'm going to get to every one of them. We're just running out of time here. Let's see. Okay, I have a question from Suzette on YouTube who says, my employer is refusing to accommodate a shift change after my maternity leave. Lior had mentioned a letter from a lawyer might help. Can they penalize me for speaking to a lawyer? Absolutely not. It is against the law for them to do anything, penalize you, any negative treatment for getting a lawyer involved, okay? Having said that, we all know there's lots of things that are illegal that people still do. So that doesn't, I don't want to say that it's impossible for your employer to do anything to you, but it's very, very unlikely. I have never seen it happen. I personally have assisted people in dealing with these kinds of issues when returning from a maternity leave or a parental leave, employers not complying with the law, not putting people back to their regular jobs, trying to make changes that they shouldn't, or not accommodating medical issues. We send a letter, we get the employer to do what they're supposed to do. End of story. There's no pushback, there's no issues for those people moving forward. I think it's twofold. I think it's because, number one, there is a law that says they can't treat you any differently or negatively because you've enforced your rights. Number two, they know that you have a lawyer in your corner now, so that if there is any other issues in the future, you're not going to hesitate to come back to us, and then they're going to hear from us again. So there shouldn't be any issues whatsoever with respect to pursuing this issue. If you need an accommodation returning from maternity leave, the employer would have to accommodate you in general. So I'd need to hear exactly what the situation is to be able to advise you further, Suzette, but generally speaking, they have to accommodate you. And like Lior said, sending a letter, we do it all the time, does help, okay? So if you would like us to do that, if you'd like me specifically to assist you, Suzette, feel free to get in touch with me. Go to employmentlawyer.ca, get in touch with me. Alternatively, you can email our main email address, help@employmentlawyer.ca, and we can connect with you that way. All right, so that's it for me for today. If I didn't get to your question, please keep in mind we have more question and answer sessions all week long next week. Our next one is on Monday, so you can tune into that one and ask your question again, or you can email us at help@employmentlawyer.ca. So thank you very much, everybody, for tuning in today, and I hope that you all have a wonderful weekend.